is an appeal in the matter of Fertre v Vale of Whitehorse District Council and others.
Yes, Mr. Fox.
May it please your lordships, I appear in this matter for the appellant with Ms Hannah Smith behind me, starting from my left, if I may, Mr Adrian Berry KC with Mr Desmond Rutledge for shelter, Mr James Burton KC.
Well, look, we've got the returns with everyone's name on them. Not these ones who've just been half filled in now, but the ones that you submitted yesterday. I think we can dispense with the introductions.
Very good. My lord, there's a short preliminary matter, which is that we seek a continuation of the anonymity order granted by Mr Justice Constable, which prohibited publication of the names of the children.
Yes,
Yeah.
well, no difficulty about that.
I'm grateful.
It's a slightly odd sort of anonymity order, isn't it, where it's just the children who are anonymised, but the mother's name is in the public domain.
It is. The children have different surnames from the mother, and it was thought that this was the minimal interference with the freedom of the press.
I'm not going to counter it, it just struck me.
Yes, it is unusual. Yes, please. My lords, the domestic rule for eligibility to homelessness assistance, with which your lordships are concerned today, was adopted at a time when EU citizens could freely enter the UK and in practice reside without a right to do so. The rule excluded people who lacked a right to reside from eligibility to homelessness assistance. Brexit made a fundamental change to the legal regime within which that small piece was located. The withdrawal from the European Union allowed the UK to abolish free movement, and it did so with effect from the 31st of December 2020. As for those protected by the Withdrawal Agreement, the UK required them to apply for and be granted a right of residence in the UK. And the first issue with which your lordships are concerned, and on which I propose to address them, and as I understand it, your lordship still wish that to be followed by the submissions of the other parties on issue 1.
Yes, perhaps this is a good opportunity to just make the point that our present provisional view, though we're not reached a definitive decision, and if it's controversial, we will hear submissions at a later stage, is that it's not appropriate for us to attempt to determine, to hear submissions on, or to attempt therefore to determine ground 3 in the context of this hearing. If that is uncontroversial, that perhaps means the timetable is a bit less tight. But if it is not controversial, sorry, sorry, I read the wrong way around. If it is controversial, and there are parties here who want to argue about it at some point, but well, perhaps I'll just ask now: is there anyone here who wishes to take the view that a court ought to hear submissions on ground 3, and therefore at least be in a position to decide ground 3 if it arises in the context of our judgment following this hearing?
My lord, it is our position that is our preferred option if the court feels that it has time to deal with the matter properly, for 2 reasons. Firstly, the issue of justification turns on some of the factual and legal context that you'll be hearing submissions on the first 2 issues. And the question of justification, we say, is relatively easy to resolve. We say in the appellant's favour, and would therefore allow the court to bring finality to the litigation at this stage, rather than either needing to reconvene to decide issue 3 or to remit it back to the High Courts. But it might be that the best course is for the court to hear the submissions on issues 1, 2, and then to see how fast things have progressed.
Well, I think yes. In a sense, you're the one who bears the burden of your own choice, because it limits the amount of time that you can develop to round 1 and round 2.
Yes.
Let's having floated it, let's park the point for the moment. But I think at some point at the end of today or the beginning of tomorrow, when it's clearer how things are going, we ought to reach a definitive view on it. Can I just hands up if there's anyone who is in the same position as Mr. Cox, namely cautiously in favour of hearing justification on this occasion? Yes, I didn't mean literal hands up, but yes, thank you. Right. But the rest either neutral or against. I already know Miss Smythe suggests, but quite firmly suggests in the Hurst-Ellison argument that we shouldn't deal with it. Very well. We'll come back to that later.
Thank you. So, my lords, I will be addressing you on ground one. And the factual context for ground one, as illustrated by the appellant's case, is in my submission an important one. It's illustrative of the situation of millions of people in the United Kingdom who hold pre-settled status, which is not in practice granted with a stamp in the passport. It's granted with an online electronic status that can be viewed as it stands at the day that one looks at the computer.
Yeah, we got a copy in the
Yes, and I just would want
the printout.
It's the only factual point I'm going to take your lordship, so I think that might I ask your lordship to look that up? It's at page 3 of the supplementary.
Core supplementary, is that right? Or is
Sorry?
is it in the core supplementary?
It's in the core supplementary.
Yeah. Yeah.
And what we see about that is that the legal basis, under the rubric legal basis of status, this leave, now leave is a right to reside, is issued in accordance with the EU exit separation agreements, and then explains that for EU citizens and their family members, that is the withdrawal agreement. There is no reference there, nor in any other formal document issued to PSS holders, that the leave that is granted is not itself a right to reside under the withdrawal agreement.
Well,
there is no published government document stating that. Indeed, the position that is advanced by the government in these proceedings was really only advanced in the way it is now by the government in these proceedings. And in my submission, that is relevant both to arguments about purpose of the withdrawal agreement, but also to arguments about the legality of the scheme. If the Secretary of State were right in her submissions that the withdrawal agreement does not allow for the granting of leave in accordance with the withdrawal agreement to a person who does not meet the conditions of Article 13.1. And I will try to show your lordships that the Secretary of State's construction of the withdrawal agreement cannot sit with the way in which the United Kingdom has implemented the withdrawal agreement. That is not to say that the withdrawal agreement mandated this form of leave. It is simply to say that the withdrawal agreement does not permit the granting of a document of this kind alongside the case that it is not the grant of leave under the withdrawal agreement. The issue one is important in a much wider sense than for benefits. Whether a holder of PSS is residing under the withdrawal agreement may also affect matters such as their immigration rights. It may be said that a PSS holder who does not meet the conditions of Article 13.1 has no right under the withdrawal agreement to defeat the revocation of their leave to remain in the United Kingdom. Now the government may say, well, that doesn't matter because our scheme doesn't provide for that anyway. Well, today it doesn't. But we don't know what the scheme will provide tomorrow. As you'll see from the news, the government changes its immigration policy and rules quite often. And that's why what matters under issue 1 is not what rights the appellant has under domestic law, but what rights are given under the withdrawal agreement. But the decision on ground 1 doesn't only affect people with pre-settled status, it also affects people with settled status or indefinite leave to remain. Because if the government is right, those people also don't have a right to reside under the withdrawal agreement unless, on their particular facts, they've met the conditions under Article 13.1, for example, for 5 years, so that they then qualify under Article 15. If the government is right that it has no power to confer a right of residence under the withdrawal agreement on people who don't meet the strict conditions of Article 13.1, then that cuts across the rights of indefinite leave to remain holders. So not only would they then not be protected by the withdrawal agreement from expulsion on the basis that they're not actually residing under it, they're not exercising their rights to reside under it, but they would also be unable, on the government's approach, to rely on the prohibition in Article 23 on discrimination. By the same logic, they would not have been residing under Article 13.1, and so would not be protected by.
Why wouldn't they be residing under Article 13? We're talking about people with indefinite leave,
Yes.
settled status.
Well, let's
The government's position doesn't say that they're not residing under the withdrawal agreement, does it?
well,
On the basis of, I guess, the technical phrase.
the logic of the government's position is the government's position in this case.
No, but the government's position is that they are bound by effectively the provisions of the Citizens' Rights Directive, because that's incorporated by the withdrawal agreement.
Yes.
So it would be a breach of the withdrawal agreement to depart from any provisions of the Citizens' Rights Directive, which does grant the right to permanent residence rights,
But
which
only
would not
after,
be revocable.
but only after 5 years satisfaction of the conditions in the Citizens' Rights Directive, not after 5 years.
Oh,
of
I
simple
see. Your
residence.
point is that you could come along in year 10 and say, well, I know you've been granted settled status, but we've now worked out that for 6 months during your period of pre-settled status, you weren't working. So
Let's take
that's
the
fanciful, isn't it, Mr.
No, it's entirely practical. Let's take the appellant's case, for example. Let's imagine that between now and November, which is when she would complete 5 years simple residence, the government decides that they no longer wish to grant homelessness assistance to people who have not been residing here for 10 years. That was a proposal of the previous government. And they enact that by changes to the regulations, but they have an exception, of course, for people who are residing under the withdrawal agreement. But then they turn around to Ms. Fertre and say, well, prove.
Yes, but that wouldn't meet the point. They would, if they had settled status, they would be under the withdrawal.
But
The fact that they hadn't qualified for pre-settled status couldn't be invoked once you granted settled status.
But on the government's argument, settled status is not residence under the withdrawal agreement.
No, I don't think that is the government. Okay, I just wanted to understand what your point
Well,
was and not enter into a debate. Let's hear, Smythe hears what your point is, and she will answer it, and then you can deal with it in reply.
Yes, my point is not that that's the government's position. My point is that that is the inevitable outcome of upholding the government's position on issue 1.
I see, okay.
That this court will be ruling that the protections of the withdrawal agreement do not flow from this document. This document is merely a gateway. To acquire the protections, a person must demonstrate on their particular facts, the case against the appellant, that they met the requirements, the strict requirements of Article 13.1.
Okay, well, I see how you put it. So
Thank you. So now we say that those outcomes are precluded by the withdrawal agreement. That's not because the withdrawal agreement requires states to grant a right to reside for everyone falling under Article 10 who's residing in their state. We accept, and we understand this to be the government's position, that the withdrawal agreement allows states to limit the rights of residents to those who meet the requirements of Article 13.1, and to thereby make that grant of resident status conditional on continuing to meet Article 13.1. In fact, that's essentially what the government says it has done for this appellant in terms of qualifying under the withdrawal agreement. What we say that the withdrawal agreement doesn't allow is to give an unconditional right of residence under the withdrawal agreement with one hand, and then to deny that that person is in fact residing under the withdrawal agreement. And we say that this scheme must be understood on a proper construction of the withdrawal agreement as having granted an unconditional right of residence under Article 13 of the withdrawal agreement. And the route that we say takes us to that outcome is Article 13.4 of the withdrawal agreement. That is a discretionary power to the state parties to grant a right of residence under the withdrawal agreement to persons who may not or do not meet the conditions under Article 13.1. Those conditions, if met, of course, require the state to grant a right of residence. And the second part of our case on issue 1 is that the withdrawal agreements confers by Article 23 a right to equal treatment on all those with a right to reside under the withdrawal agreement, subject to the narrow exception in Article 23.2. Now, below, both the Secretary of State and the IMA, this case rested essentially on opposing the first part of that argument. Secretary of State argued then, as she still argues, that Article 13.4 doesn't confer any power to waive the conditions and limitations for a resident's right under the withdrawal agreement. Then her case was that it didn't confer any power at all. The case has shifted in this court, but where to we say is unclear. Secretary of State now seems to accept that Article 13.4 can be used to grant a residence right in individual cases. That's in her skeleton. But is silent as to why a power to grant in individual cases can't be the basis for adopting policy on the use of that discretion in a class of cases. That's what we say has happened here. IMA now accepts that the appellant has a right to reside under the withdrawal agreement on the basis that she meets the conditions in Article 13.1 by virtue of the fact that she was granted pre-settled status before the end of free movement. And I'll show you the route for that later. The IMA skeleton point on Article 13.4 is that the discretion is unlikely to be broad enough to collapse the distinction between pre-permanent and permanent residence rights this way.
Sorry, just tell me what it is you say IMA accepts.
IMA, as I understand it, exception, I'm looking at this skeleton at paragraph 45, that she does meet the conditions in Article 13.1.
Sorry, just so I can understand the structure of your submissions, Mr. Cox, I've assumed these were largely introductory.
These are.
So I'm only keeping a rather general note.
Yes.
So all these points you're going to come back to in more detail, are
Yes.
you? Okay.
I'm trying to set out what the context is.
Okay,
for brief.
it's quite difficult.
I'm sorry.
There's a lot of detail here, and to do it all introductorily,
Yes.
I mean, the sooner you get onto the substantive submissions, I think
That's
the
the end of
better.
my introduction.
Okay, that's very helpful.
So
Thank
that's
you.
the substantive.
Can I just pick up one point, please?
Yes.
Only really to focus on what I take away from this introduction, which is that your case hinges on Article 13.4. Not only do you say is there a discretion to waive the conditions in Article 13.1, but that discretion was exercised at a policy level in this case and is the underpinning of what we see as the law now.
Yes.
In the pre-settled status.
Yes. And there is no material that isn't the case. There is only a legal argument that it can't be done. There is no material that if it can be done, it wasn't. So the Secretary of State's case is, I couldn't have done that. But there's nothing before you.
So there's a Vare's issue about what Article 13.4 means and its scope, is that right?
Essentially, yes. I mean, yeah, that is the issue, yes. The case of the Secretary of State and the IMA is you can't do that under 13.4.
Does it go that far?
Yes. But there's never been a fallback case advanced that, well, let's assume that we can.
There's no argument that if you can go that far, it wasn't done in this case.
No, haven't we? No. So the structure of the submissions on issue 1, I propose to take the court first to the EU law provisions, because they are very relevant to the interpretation of the withdrawal agreement. Then the text of the withdrawal agreement itself. When we get to Article 13, I will take your lordship to the case of CG, which concerns the operation, admittedly, of the EU law scheme, but it's relevant to Article 13, and then the case, the judgment of this court in 18. And then I will deal with take my submissions under Article 18. And then after dealing with the withdrawal agreement, I'll turn to the Secretary of State scheme and then the judgment below. So if I can ask the court to turn up the Treaty on the Functioning of the European Union, which is in the Authorities Bundle Divider 3. Sorry, yeah, Divider 3, Volume 1, Divider 3. Page 177.
Oh, now how very tiresome. I'm sorry about this, through my own incompetence. I haven't got Authorities Bundle 3.
This is Authorities Bundle 1, I'm so sorry.
Oh, I'm so right.
It's Divider 3, it's mine. I misspoke.
We will, however, in due course be getting to. I might ask, could you, well, annoyingly, my clerk isn't here. If you could email your Justice Newey's clerk and ask her to bring Authorities Bundle 3 from my room, with apologies. Thank you. Is that right?
So if I could ask you, Lordship, then to turn to page 177 of the Authorities Bundle, Volume 1, Divider 3. There are some extracted texts from the Treaty on the Functioning of the European Union. The first one, it's really just for context, is Article 18 of the treaty, which is the general prohibition on discrimination under EU law, within the scope of application of the treaties and without prejudice to any special provisions contained therein. Any discrimination on grounds of nationality should be prohibited. Then your Lordships would turn to Article 21, page 180. Crucial provision is paragraph 1. Every citizen of
Hold on a
the...
minute, sorry, I'm doing electronically. Where are we going?
180.
So which was the article you were taking us to before?
Article 21.
No, before.
Oh, 18, page 177.
Okay.
Then Article 21 at 180. Every citizen of the Union shall have the right to move and reside freely within the territory of the member states, subject to the limitations and conditions laid down in the treaties and by the measures adopted to give them effect. Now, importantly, as we shall see when we get to CG, when a member state grants a right of residence to a Union citizen, which is not required to be granted by the directive, that constitutes a waiver of the limitations and conditions referred to in Article 21. So that person thereafter, for the duration of that domestic grant, is residing under Article 21 of the treaty.
Sorry, say it again. When we get to
So the Court of Justice in CG held, I can take your lordship to it if that would be easier, but I propose there are a number of points coming out.
well, just tell us what the point is. I just didn't get it.
The Court of Justice
CGU says what?
says that where a member state makes a domestic grant of leave to a person who does not meet the requirements of the measures under Article 21, that person is thereby residing under Article 21 without needing to meet the limitations and conditions.
Okay.
Now that right is revocable, it's not a permanent state of affairs, but while they hold it, they're not simply residing under domestic law, they're residing under Article 21. But they're not, as we shall see, residing in compliance with the conditions of the Citizens' Rights Directive. And the last two provisions I want to take the court to, page 181, Article 45, because these are referred to in the Withdrawal Agreement, which freedom of movement for workers shall be secured within the Union. And Article 49 over the page at 182, which confers the same rights on the self-employed. Those are the provisions of the treaty. Let's take your lordships to. I want to turn now to Directive 2004/38, or the Citizens' Rights Directive, that is at divider 4. But also that your lordships have been provided with a copy, and I have a hard copy, additional hard copy.
If you wouldn't mind, the problem with these printouts from the internet is that they don't give you the structure. So it says that this title, and you can't actually find a heading which shows what title something is under.
Yes.
And that's why perhaps a general rule people might notice when putting bundles of authorities together.
Absolutely.
Yeah.
The issue that we haven't solved, I'm afraid, with the better in that version 2004/38 is that the print is smaller.
Well, that doesn't matter. Well,
but can I also at the same time hand
So
up?
which version are we? Do you want us to look at the one that was sent through yesterday?
I'm happy for you to look at the one that was sent through yesterday. Yes.
I haven't printed that out. It seemed to have a rather large number of pages, and I don't have it in hard copy.
but that I think is what's coming up. Well, hang on. I've been given a single.
the one
But
you
there's
have in-
three of us.
Yes, the one you have in your hand. I'm so sorry, I should have broken it out, perhaps. But the one you have in your hand, my lord, is multiple copies of the document that we're looking at now, 2004/38.
Is it
So you'd
something?
like? Well, hang on. So
So sorry.
Is it something different from what we've already got?
It's a hard copy of what you were sent by email yesterday.
So
well, there
I
seems to be
printed
lots of.
out- I printed
it out.
This is. I can't sit here and do this. Somebody. So. Can you? Sorry. Do take it back.
Yes.
Can somebody? It may be that we can manage with what we've got. I find it inconvenient for the reason I gave,
Yes.
but nevertheless, I would like to have a hard copy, if only for later. So can somebody, not you, divide that up into so we get one copy each, or whatever it is you want to give us. This hasn't been thought through by somebody, but
Sorry.
there we are. Don't worry. Right, let's use the one we've got for the time being. It's not the end of the world.
So starting then at Article 3, which is at page 3 of the new version and page
Well, we haven't got the new version yet, so just
191 of the old
Yeah.
version. So page 191 of the old version. Unfortunately, I'm not sure that the chapters are crucial for this directive. So this states the beneficiaries of the directive. We see shall apply to union citizens who move to or reside in a member state, other than that of which they are a national. Turning over then to page 195. the Article 6 right of residence for up to 3 months. Union citizens shall have the right of residence on the territory of another member state for a period of up to 3 months without any conditions or any formalities. And then on the next page, the right of residence for more than 3 months under Article 7. And Article 7.1 relates to union citizens, says they shall have the right of residence on the territory of another member state for a period of longer than 3 months. And then there are 4 categories. The first is workers or self-employed persons. The second is self-sufficient persons. That's persons who have sufficient resources for themselves and their family members not to become a burden on the social assistance system. C is the same but students, so self-sufficient students. And D is family members, one of the first 3 groups. And so those are the essential conditions for residents under the Citizens' Rights Directive. Article 8.
Just before we move on, I'm a bit slow, I'm afraid, because I marked up the other version, so I'm now, that's okay, but I'm just trying to catch up. Is it common ground that this appellant does not come within Article 7?
Yes, for at material time, which is when the decision under appeal was made by the local authority. Article 8, and I take your lordship to this because it's relevant to understanding the withdrawal agreement, the form of the withdrawal agreement. Article 8, administrative formalities for union citizens, and illustrative of those formalities or the limits on them. Paragraph 3, for the registration certificate to be issued, member states may only require that.
Well, don't we need one? Periods of longer than 3 months, host member may require new members to register.
Yes,
Sorry.
which
Yeah.
is not a requirement that the United Kingdom adopted. 3, for the registration certificate to be issued, member states may only require that. And then union citizens to whom point A of Article 7.1, which your lordships will recall as worker or self-employed person, present a valid identity card or passport to confirmation of engagement from the employer or certificate of employment, or proof that they are self-employed persons. And then the other provisions make similar limitations for the other classes of people with the right to reside under Article 7. There is one additional article that's relevant to the right to reside, which
Why
is
are we showing Article 8? Because we didn't do Article 8, did we?
sorry.
Why are we being shown
I'm
Article 8?
showing you Article 8 because when we get to Article 18 of the withdrawal agreement, you'll see that it copies and pastes Article 8 in part. So that's relevant to the government's defence that Article 18 isn't about conferring a substantive right of residence at all. It's only about a gateway, which we say is wrong. So turning to Article 14 at 207. One, union citizens and their family members shall have the right of residence provided for in Article 6 as long as they do not become an unreasonable burden on the social assistance system. So I'm simply trying to show you, lordships, the geography of it. In other words, you do have a right of residence for 3 months, and you could keep
Sorry to
going
be
back.
pompous about this, but it is your lordship's and your ladyship.
I'm so sorry. I didn't
Because
know.
I hadn't even noticed. Shows
I'm
how-
sorry.
Oh, sorry.
Oh, it shows how hard
I'm being
I am.
oversensitive on
Thank
that.
you.
Didn't.
If my lady doesn't mind,
No, I didn't
Well,
say
no,
that, I
I'm
hadn't
happy
even
to adopt
noticed.
it, my lord.
I don't mind.
I've been with other panels where I didn't appreciate that was the preferred nomenclature.
well, mate,
But I'm happy to do it, of course. At Article 14.1, there's a limitation on the right under Article 6 in a case of a person who becomes an unreasonable burden on the social assistance system of the host member state, which would address the case, for example, of a person who keeps coming and going and keeps saying, well, I've only been here for 3 months. And at Article 14.2, we see that the rights of residence under Article 7, 12 and 13 don't really matter for today's purposes, as long as they meet the conditions set out therein. And there is an additional clause that in practice has been seen as adding a right to reside, which is Article 14.4, and albeit it's expressed somewhat differently, it says, by way of derogation from paragraphs 1 and 2, and without prejudice to the provisions of Chapter 6, Chapter 6 is public policy. An expulsion measure may in no case be adopted against union citizens or their family members if, A, they're workers or self-employed persons, but the relevance of it is B, the union citizens enter the territory of the host member state in order to seek employment. In this case, the union citizens and their family members may not be expelled for as long as the union citizen can provide evidence that they are continuing to seek employment and that they have a genuine chance of being engaged. And I mention it because it's one of the provisions that is referred to in the withdrawal agreement. Then the last two articles from the directive I want to take you to 219, Article 24. Which is the equal treatment clause. Subject to such specific provisions as are expressly provided for in the treaty and secondary law, all union citizens residing on the basis of this directive in the territory of the host member state shall enjoy equal treatment with the nationals of that member state within the scope of the treaty. Now the phrase is directive, and that's entirely understandable because this is a directive and it's only talking about those with a right to reside under the directive. It is not, does not say EU law or Article 21. It's a rule that applies to those residing or who.
Yes, but there wouldn't be any greater rights under Article 21, because Article 21 is itself, of the TFEU, is itself subject to detailed legislation, and this is the detailed legislation. So I'm not quite sure what point you're making.
The point I'm making is a preface to what you'll see when we see Article 23 of the withdrawal agreement,
Yes.
which the government and the IMA say is intended to operate in the same way as Article 24 and therefore has the same personal scope as Article 24. Persons residing on the basis of the Citizens' Rights Directive, whereas I say the personal scope of the withdrawal agreement article is what it says, which is persons residing on the basis of the withdrawal agreement, which is as we shall see, a much larger class of people. So I'm simply showing you that as a preface. I appreciate there's a...
Yeah, okay, that's fine, got it. Yeah.
And the last...
But so far, and I just put a pin in the pathway, we're all agreed on that this appellant had no rights under the directive of the CRD.
We are all agreed that this appellant did not meet the conditions.
So she was not a citizen residing on the basis of this.
She was not. She was not. These are all points about that are preface my submissions about the changes to the legal
Right, so you, okay, yes.
and that the textual changes represent substantive changes. And then lastly, Article 37. Which again has a similar, textually similar provision in the withdrawal agreement. The provision, it's at page 234, my lady. The provisions of this directive shall not affect any laws, regulations or administrative provisions laid down by a member state which would be more favourable, and again, to the persons covered by this directive.
Just remind me, where in the Citizens' Rights Directive does the right of permanent residence?
I'm so sorry.
Where in the Citizens' Rights Directive is the right of permanent residence?
15, my lord, which is 209. Sorry, I'm so sorry, 16, 210. Thank you. And so we see Article 16, union citizens who have resided legally for a continuous period of 5 years in the host member state. Now, the court has glossed that to mean in compliance with the conditions of the directive.
Which case is that?
Tsiolkovsky, which we do have, and I can take you to if needs be. So I propose to leave, if I may, the Citizens' Rights Directive and ask your lordships to look at the withdrawal agreement. And we do have individual copies of the version that was sent by PDF yesterday for members of the court who have not printed it out. They are there.
I didn't print it out. I wasn't actually going to ask for it. Because it's so substantial. I thought we could cope, and you did give us, which we didn't have for the Citizens' Rights Directive. We did have a table of contents. So with some difficulty, you could work out which title was which. Having said that, if it has been printed and it's ready to be handed up,
It is there. So
we will now have it.
perhaps I might hand up 2 copies, and I also have, in case your lordships want it, copies of the a hard copy of 2004-38, as I understand.
Okay, well that's helpful as well. Thank you.
2 copies because my neighbour really has one.
Is it-
Okay, what am I meant to do?
Do you want a hard copy?
I'll take anything you've got, but are we dealing with this electronically? Because I would prefer
I'm happy to deal with it.
electronically.
I'm happy to continue to deal with it electronically, my lady. I have references in my
Would you
notes
please, can we do both?
to the electronic
please?
pages. Yes.
You can- Thank you very much.
And we'll be starting at page 107 in the electronic bundle, and also in this.
I think, unless my lord is inconvenienced by this, let's just use the references in the bundle we've got.
Very good.
The important thing is to have this so that if I want to see structural points, I can do so more easily than on the.
Yes.
But we won't use this in the course of your submissions.
Right. So I just want to start with a structural point about the scheme of the withdrawal agreement, so your lordships can see, well, it's a guide, hopefully, to working out what the provisions mean when it says this title of this part.
Yes.
So the withdrawal agreement has 6 parts. We are essentially only concerned with 2 of them, albeit references possibly to the provisions on the coming into force of the agreement. Part 1 is the common provisions. Follows the preamble, but as your lordships and my lady will see, Article 1, objectives, 2 definitions. I'll be taking you to those briefly. Article 4, the methods and principles. Article 5, good faith. Article 6, references to union law. The part that we're principally concerned with, Part 2, Citizens' Rights, is divided into 4 titles, and we are essentially concerned with Title 2. Title 1 is the general provisions, and Article 10 there is important. It's the personal scope of Part 2. I'll take you to that. Article 12 is a general non-discrimination clause, and then we see in Title 2 the rights and obligations, and divided into 3 chapters, and we're really only concerned with the first one. Rights relating to residence and residence documents. So we shall see Article 3, residence rights, is crucial. Article 5 is a right of permanent residence.
Sorry, say 5, do you mean?
Article 15, I'm so
You
sorry.
mean Article 13 and Article 15?
Article 13, I'm so sorry, and Article 15, right of permanent residence. Article 18 is issuance of residence documents. And then over the page, Article 23 is equal treatment. The last provision that I will take you to is Article 38, which is in Part 2, but Title 4 of it, more favourable provision. But it's important to note, though, that the distinction between Title 1 and Title 2 of Part 2, as we shall see, Articles 13 and 18 refer to this title, Title 2, which does not contain Article 10, personal scope. That's not to say that it's any larger than the personal scope in Article 10, of course not. It's simply to set up the submission that those provisions are talking about, that Article 18 is talking about Article 13 not Article 10. The Part 2 is in force only from the end of the transitional period, and we see that from Article 185 of the Withdrawal Agreement, which is page 175, the electronic bundle. If I could just take your lordships there.
Sorry, which page did you say?
It's 175.
Yes.
So we see at Article 185, entry into force and application. The general rule is that the agreement enters into force on the United Kingdom leaving the European Union. That's what the first few paragraphs provide for. But your lordships will see the penultimate paragraph before the indentations, parts 2 and 3, with the exception of Article 19, which is the relevant one for our purposes, as well as.
But you say Article 19 is the relevant one for our purposes.
Well, I'll take you to it, but Article 19 is the article that provides for the operation of Article 18 decisions that have already been taken to be operative from the coming into force of Part 2.
Oh, I see. Okay, we'll go back to that in a minute.
But
yeah.
I'll take you to it, but I simply wanted to show you that generally Parts 2 and 3 don't apply until the end of the transition period. In other words, they didn't come into force in January 2020, they came into force on the 31st of December 2020. But the other provisions, the interpretative provisions and so on, for that's worth came to force immediately. So turning then to look at the provisions in question, if we could start with the preamble at page 114. The fifth recital, beginning stressing that the objective of this agreement is to ensure an orderly withdrawal, recognising it's necessary to provide reciprocal protection for Union citizens and for UK nationals where they have exercised free movement rights before a date set in this agreement, and to ensure that their rights under this agreement are enforceable and based on the principle of non-discrimination. And then resolved to ensure an orderly withdrawal. And then at the end of that line, and to provide legal certainty to citizens and economic operators, as well as to judicial and administrative authorities in the Union and in the United Kingdom. And I will rely on these provisions to support my arguments on the interpretation of the substantive provisions of the Withdrawal Agreement. And then on the next page, the sixth recital, full recital there, underlining that this agreement is founded on an overall balance of benefits, rights and obligations for the Union and the United Kingdom. So this is, if it needs to be said, a new arrangement. It is not the old arrangement. And the old arrangement is not to be taken to continue, except where the new arrangement provides for it to do so. In fact, those are very much the Secretary of State's submissions, as we shall see in 18. Turning then to page 120, Article 4. Methods and principles relating to the effect, the implementation and the application of this agreement.
So sorry, which page did you say?
120.
Yep.
Article 1, the provisions of this agreement and the provisions of Union law made applicable by this agreement shall produce in respect of and in the United Kingdom the same legal effects as those which they produce within the Union and its member states. Accordingly, legal or natural persons shall in particular be able to rely directly on the provisions contained or referred to in this agreement, which meet the conditions for direct effect under Union law. Now, some of the government submissions seem to suggest that the agreement expects or intends the outcome not to change. But that's not what this provision provides for. It's the legal effects of the agreement shall be standard across the United Kingdom and the member states. And it follows, therefore, that if a member state takes a very different approach to implementing the right of residence, a less generous approach, that the practical effects in that country will be very different. But what matters is that the legal effects of, for example, the exercise of a discretion would be the same whether they were here in the United Kingdom or in Hungary. And I make that submission because it seems to be suggested in some of the arguments that this is a case about a burden on the United Kingdom that the United Kingdom has not taken on voluntarily. But what this is really a case about is about the rights that flow from decisions of the government under the Withdrawal Agreement. And what's important is that those rights that flow from those decisions are the same across the Union. It's not that the decisions are the same. Paragraph 3, the provisions of this agreement referring to union law or to concepts or provisions thereof shall be interpreted and applied in accordance with the methods and general principles of union law. So what that doesn't say is that where the text or the context has changed, that the outcomes will be the same. And therefore it's important to distinguish between what has changed and what remains the same. And in my submission, in a sense, that's what the argument between us is really about. Paragraph 4 provides for the provisions of the agreement referring to union law or to concepts or provisions thereof shall, in their application and interpretation and application, be interpreted in conformity with the relevant case law of the Court of Justice of the European Union, handed down before the end of the transition period. And lastly, before we leave the preliminary articles, Article 5, good faith. The Union and the United Kingdom shall, in full mutual respect and good faith, assist each other in carrying out tasks which flow from this agreement. They shall take all appropriate measures, whether general or particular, to ensure fulfilment of the obligations arising from this agreement, and shall refrain from any measures which could jeopardise the attainment of the objectives of this agreement. And the significance of that is for the issuing of documents which state that a person has leave to remain under the withdrawal agreement, alongside a legal contention that that is not what the document means. The government's position is inconsistent with the documents that it issues. And certainly it's our case that that interpretation would lead to jeopardising the attainment of the objectives of the withdrawal agreement.
It was probably that argument's in your skeleton.
It's not spelt out in the skeleton. It's an interpretation point. It's not an argument that the government is breaching the withdrawal agreement. It's an argument that the government would be breaching the withdrawal agreement if the position were that it were issuing documents that say you have leave under the withdrawal agreement when you don't.
It's a bit far-fetched, isn't it? Where do you get that from Article 5?
Well, the need of the right to legal certainty of citizens and others to be able to rely upon the documents that are issued under the withdrawal agreement as meaning what they say. But
well,
so the challenge you sorry.
Well, I was just saying, a certain amount of criticism of you below. I'm taking no position on whether it was justified. That your case was rather evolving as you went along. I don't think it's very satisfactory that an Article 5 point has been taken for the first time in oral submissions, where not having raised either below or in the skeleton argument.
Well, I hear what your lordship says, but in my submission, it's inherent in the case that we make that the position that the government takes is incompatible with the articles of the.
Well, that's fair enough, but good faith is different altogether.
Well, perhaps if I can, I'll think
It's
about
not
it.
your thing. It's not. Your points are just as good without putting a good faith flavour on it,
Thank you.
good or bad. But I mean, they're not changed. That's the substance of the arguments. Yeah. Okay.
So turning then to the part 2, which, as I've shown you, is only in force, generally speaking, from the end of the withdrawal, end of the transition period. Article 10 at page 127 sets out the personal scope applicable to, generally to part 2, albeit, as we see from the opening words, without prejudice to title 3. Title 3 is social security coordination, and therefore would apply, for example, to an EU citizen who had left the UK long ago, but wished to receive a retirement pension under contributions paid in the UK, which is why there's an exception for Title 3. And there's a number of classes. The appellant falls under Class A, Union citizens who exercise their right to reside in the United Kingdom in accordance with Union law before the end of the transition period and continue to reside there thereafter. And what's significant for my purposes is that it's not in accordance with the CRD, it's in accordance with Union law. So the personal scope of Article 10 applies to all the different species of rights of residence under Article 25, under Article 45,
Sorry, have you shown us Article?
under Article 21, I'm so sorry, and under Article 45, I'm sorry.
But we've already had this point that there are those general rights in the TFEU, but they are expressed to be subject to, I'm not using the correct EU formulation, but subject to more particular legislation. And we have the more particular legislation in the directive. So
We have
is there any real difference between in accordance with Union law and in accordance with the directive?
Yes.
Why?
Well, firstly, because as we shall see from AT, it applies to those whose right to reside is only under Article 21, even though they did not meet the conditions of the CRD, because they have a grant of a domestic leave to remain. And secondly, because there are a number of other classes of people, for example, who were not addressed in the directive and who fall outside the scope of the directive. For example, pregnant women who have been self-employed or have been workers and who have been found by the Court of Justice to have rights to reside under Article 21 or 45 or 49, albeit not under the CRD. The most obvious case is that of the parents of the children of workers who are in education.
So who are in education, the workers or the parents?
The children are in education. So the parents of children in education where they are the child of EU workers. With the Secretary of State.
Sorry.
So.
What you about workers who are in education? Which is not.
I'm sorry, my lord. There is a class of people under the court's case law who have a right to reside because they are the carers of.
Parents, sorry, I was
Yes.
parents.
They may be the parents, but
Is
This is Zambrano. Are we in Zambrano?
no, we're in Teixeira and Ibrahim.
Isn't that a sort of subclass of Zambrano? Teixeira.
No, Zambrano is about.
Okay. Well, so it'd be direct to.
Zambrano is
well-
about EU citizen children who have no other connection to the EU law system. They are not provided for in Article 10.
Okay. I don't want to bog you down if you're just making general points, which you're going to make more particularly later.
Well,
But you were keen to emphasise to us that this said union law and not just the directive.
yes,
And I was saying, what is there apart from the directive? And you were saying could be Article 21 or Article 45 or Article 49.
yes.
And then you were giving another example. But is this example important to your case? In which case, at some point, we need to have it fully explained to us.
It's an
If
example.
it's not important to our case, then we'll move on.
I will return and more fully explain it, but it is an example of a right to reside that is derived from either Article 21 or Article 45,
I see. So this comes under 2145. It's simply an example, and these are examples you're mentioning because they appear in the case law.
Yes.
So what's the name of the case that exemplifies this? You say
So
Teixeira.
there's a case called Teixeira, which is T-E-I-X-E-I-R-A,
Okay.
and Ibrahim.
That's a different case, or
They are two different cases on the same point.
okay? Well, that's fine. We'll come back to them if they appear to be important later. Thank you.
But the government accepts that those people fall under the withdrawal agreement
Okay.
and gives them resident status under the USS because they were residing in accordance with union law.
Okay.
But they do not and did not meet the conditions of the CRD.
Right. Thank you. That's clarified what you're saying about 10A. Anything else?
And the last provision in Title 1 is Article 12, which is the umbrella or general non-discrimination clause. In a crudely speaking, a similar sense to Article 18 of TFEU. Within the scope of this part and without prejudice to any special provisions contained therein, any discrimination on grounds of nationality within the meaning of the first subparagraph of Article 18 TFEU shall be prohibited in the host state and the state of work in respect to the persons referred to in Article 10 of this agreement. The special provision for this case is Article 23. But I mention it so that your lordships can see the overall scheme.
So, although it doesn't appear in this printout, Article 12 is the end of Title 1.
Yes, unfortunately, beneath it, it says enacting terms, and there it says Part 2 Citizens' Rights, Title 1 General Provisions.
Yeah, that's.
And on the next page, your lordships will see Article 13 is Title 2 Rights and Obligations.
Yeah, that's fine. You
But
see
it's
how
the
different,
last
but you really have to be eagle-eyed to spot
You
that.
do. It's
But I wasn't making a point about having the printout. I just wanted to make sure where the break came.
Yes, it
Yeah.
comes between 12 and 13.
Yeah. Okay.
So then turning to Article 13, which is the first key article that I want to make submissions on. And firstly, starting then with the text of Article 13. Article 13.1 is the provision relating to union citizens who are residing in their own right. 2 and 3 are family members. Article 13.1, union citizens and United Kingdom nationals shall have the right to reside in the host state under the limitations and conditions as set out in. And then firstly, Articles 21, 45 or 49 TFEU. And in my submission, it's significant, and it was significant in 18, that Article 13 doesn't just refer to certain provisions of the Citizens' Rights Directive, but refers to Articles 21, 45 or 49. And in Article 6.1, point A, B or C of Article 7.1, Article 7.3, Article 14, Article 16.1 or Article 17.1.
And just so that we remind ourselves what those are, Article 6.1 is under 3 months.
Yes.
Article 7.1 A, B to C is workers self-employed and students.
Workers self-employed.
Workers self-sufficient and students.
Yes.
It omits D, this may not matter, but just for clear thinking, family members. So family members aren't caught by this.
They fall under 2.
Okay, that's right. Of course they are. That's right. Article 7.3, remind me.
Article 7.3, I'm sorry, I didn't take the court to it. It is relates to the person who's deemed to continue to have worker status.
Okay, it's a footnote, but it's a footnote class.
So it's another form of
deemed
worker.
continuing workers. Yep. Okay.
14, I took your lordships to. It's in particular the prohibition on expulsion of people who are actively seeking work.
Yeah.
16.1 is the right,
is more than 5 years.
which is yes, exactly. It's the right of permanent residence on 16.1. So we see that in Article 13.
Yes, that's fine.
Even though it might be thought to only relate to pre-permanent residence, it's also relating to permanent residence. And Article 17.1 is
Why do you say why it might be thought to refer.
It's sometimes referred to as relating only to pre-permanent residents.
Okay, but logically, you're expected to cover all kinds of residence rights that existed before, which would
Yes.
include permanent residence.
You would. Well,
Yes, okay, that's fine. Yep.
and then Article 17.1, which is a special case of people with the right to permanent residence acquired, for example, where they've become permanently incapacitated from work, or where the principal has died. So it's another form of permanent residence under another route to permanent residence under the citizens' rights.
That's helpful. Thank you. Yes, okay. It's just useful to have all these labels.
Absolutely. And so 2 and 3 are similar structure, though slightly different wording, curiously. But we don't see anything turns on that. But they relate to family members, and they also list, in the case of family members, you'll see only Article 21, TFEU, and then some different points under Citizens' Rights Directive. And then Article 13.4, which is crucial for my case, 2 sentences. The first, the host state may not impose any limitations or conditions for obtaining, retaining, or losing residence rights on the persons referred to in paragraphs 1, 2, and 3, other than those provided for in this title. So that's Title 2. It's not limited to Article 13, the conditions and limitations and conditions. So any limitations and conditions under the title. And what that means is that the limitations and conditions are not guidelines. They are, as referred to in AT, and IMA, they are limitations and conditions that cannot be overstepped. And then the second sentence.
Just pausing that, I don't think this matters, but since we're poring over this subparagraph, I better understand every bit of it. Or losing. I understand a limitation or condition for obtaining or retaining. That may mean, you can imagine plenty of limitations, and it says you can't do that unless it's specifically provided for. Or losing. What's a limitation or condition for losing residence rights?
Well, I think that the language.
It really must mean something like circumstances in which you lose.
Yes.
Yes.
Or it might be, for example, expulsion. In other words, it's a reminder.
It's all right. No, it's just the English didn't quite work. A condition for losing. It really means a provision which means that you would lose it. Yep. Okay, that's fine. I've got that. I don't want to spend any more time.
Limitations and conditions relating to.
Yeah, I mean, it doesn't matter.
But I think it's an important reminder that there's a very precise dependence on prepositions may not be the best guide to the intent.
Let's not spend any more time. I wasn't thinking about prepositions. It was the word condition was more.
Well,
anyway, it doesn't matter. Then the second half, as you say, is different. And what are you about to say about that?
There shall be no discretion in applying the limitations and conditions provided for in this title other than in favour of the person concerned. Now, I say what that does is it recognises that the states may exercise discretion in favour of persons concerned in relation to residence rights.
Hang on 1 second.
So if there's a discretion there in favour of the person concerned.
In relation to residence rights.
It's not providing for it. The actual provision is the opposite. It says there's no discretion, but it's an exception to the discretion. It says you can be more generous.
Yes, it's what was referred to by Lord Justice Green in AT as asymmetrical. But I say there's no limitation on the asymmetry. There's no textual limitation on it. and the location of it indicates that the parties to the agreement intended it to relate to residents' rights. That's the title of the article. And the first sentence of that paragraph, it discusses limitations and conditions for obtaining, retaining or losing residents' rights. So we're not concerned with the possibility that it might be concerned with residents' rights. It obviously is about residents' rights.
Can you help me on your argument for Article 13.4, because you place very great emphasis on it when we
Yes.
introduced the case. First sentence, I'm sure this is in your skeleton, it would help me just to have it now, it's on the screen. Do you place any emphasis on the first sentence? Because on a first reading, you would say that the appellant doesn't have a right referred to in paragraphs 1, 2 or 3, because we've already canvassed this. She doesn't, at the time of the decision, have a right under Article 7.1, A, B or C. So she doesn't have any CRD rights. Are you saying that she has a right otherwise provided for in this title? Or does this first sentence fall away completely?
No, I'm saying the first sentence, so first of all saying she doesn't have a right, subject to the argument about reliance on her PSS already bringing her into Article 13.1, which is not an argument about 13.4. But so on the assumption that she's not a person who met the strict conditions referred to in Article 13.1, then I accept that she didn't have an enforceable right against the United Kingdom to reside in the UK.
So it follows from that, which I think was my lady's point to you, that this is about the second sentence, not about the first.
It's about the second sentence, but the first sentence gives context to the second sentence.
Well, only in this sense that it makes clear what you were keen to emphasise, that it's about residents' rights. Is that, what other context does it provide?
No, that is the context.
Yes, I
and
see.
then
Yeah.
it's
No,
about
well, speaking
obtaining,
for myself, it seems fairly clear, but
and it's about obtaining, retaining, or losing residents' rights. Those three scenarios: not only obtaining and not only retaining, but all three. And I say that is a recognition by the parties that they wanted flexibility in terms of providing more generously for the people to whom Article 10 applies. They were not prepared to allow each other the right to be less generous, but it was important for them to spell out that they were allowing each other the right to be more generous.
And more generous in a way that is not simply an aspect of domestic law, because that's provided for elsewhere.
More generous within the scope of the Withdrawal Agreement. Yes. Article 37, as we should come to, tells us that the parties may be more generous outside the Withdrawal Agreement, but what I say the parties wanted, sorry, Article 38, what I say the parties wanted to achieve, as is evident from this clause, is the power to be more generous within the Withdrawal Agreement.
Now, why would they want that?
Well, as we shall see, because the United Kingdom didn't want to have to ask everybody what kinds of rights they had under Article 13.1 in order to be able to issue them with a document under the Withdrawal Agreement.
But why wouldn't they be happy to achieve that as a matter of domestic law rather than bringing in the Withdrawal Agreement?
Why wouldn't the parties might have decided that they weren't going to allow each other any discretion, that the Withdrawal Agreement could only be applied or this part of it could only be applied in strict compliance. But I say that,
I'm sorry, the party couldn't possibly have intended individual states not to have the right to give residence rights to whoever they liked, whether or not under the withdrawal agreement.
Well, it's not the whether or not, it's whether under that's the issue.
Yes, but it doesn't really matter whether it's under.
Well,
What matters to you now for the particular reasons in this case. But the real importance is that the UK, but it could be France, it could be anyone, but the UK should be able to say, well, I know you're not entitled to rights under this agreement, but I want to make it clear that I can give you rights under my own domestic law, which will be equivalent to the rights under the agreement. Now, isn't that all you'd expect a state to want to say?
Well, no. I mean, for example, there are many reasons why states would want to be able to act under the withdrawal agreement. So if you take, for example, Spain, which has a number of citizens from different EU countries, but also the UK. Let us suppose that Spain has a long established practice of waiving a particular provision of the Citizens' Rights Directive and giving leave to remain. And it knows, as we'll see from the case law, that person is still residing under EU law. So they can treat them as an EU law case. And they want to go on doing that for United Kingdom citizens. And they want to be able to just keep them in the same legal space as with the withdrawal agreement.
But they can do that by their domestic law, saying we will treat you as if you're covered by the withdrawal agreement, even though you're not.
Well, the problem with that is it might not produce the same legal effects.
It would, if that's what you said.
Well, it wouldn't under EU, it might not under EU law.
Would that matter? All that matters to the citizen is I'm entitled to live here, I'm entitled not to be expelled, I'm entitled not to be discriminated against. If all those rights are given by the domestic law,
Well, what matters?
it's a matter of two hoots, whether to the person affected, whether it's characterised as being under the withdrawal agreement or not.
But it might matter for whether or not it's under the withdrawal agreement, because it might determine what in fact their rights are if there's an argument about what those rights extend to. But also it might matter for the state.
Well, it would tie the state's hands, but why would the state wish to have its hands tied?
Why would the state wish to not be able to have its hands tied?
Because it could do what it liked.
But it can't do what it's like. But it can't do what it likes if you're against me on the interpretation of 13.4. It can't say to somebody, we don't care whether or not.
Well, we're exploring why your interpretation of 13.4 should be right, why it should be something that the signatories to the agreement intended to achieve.
Yes.
And at the moment, I can't see any particular point. Certainly, it's not how I would have drafted it if it was what I was intending to achieve. But even leaving that aside, I can't see any particular reason why a member state would want to retain the right to grant rights under the withdrawal agreement, I mean, other than those for which the withdrawal agreement provides, and yet have them characterised as under the withdrawal agreement. If you want to grant rights other than those for which the withdrawal agreement provides, fine, you may want to have that recognised, but almost by definition, they will be rights under domestic law.
But if you want to not inquire into the satisfaction of a particular condition under Article 13.1, and you want your officials to be able to issue a document to this class of people which recognises that they fall under the withdrawal agreement, even though some of them might strictly not have on a closer examination.
Surely the citizen doesn't care tuppence whether they're under the withdrawal agreement. They will want to know that they've got the rights to be under the EUSS. That's what they'll be interested in.
Well, but the state wants to know that they're under the withdrawal agreement.
Well, normally it won't matter, but in some particular cases it will, and then you can have a look at the withdrawal agreement, see whether it's covered or not. But this case is an example.
But I say that the states would have had no reason to put out of their hands the right that they already had under the EU treaty, as we shall see, to buy a domestic grant of leave
this
to
depends
remain.
on the cases which you've trailed, but we haven't yet looked at. So let's pause this bit of the argument. It's important to have it now while we're looking at 13.4, but you say it's going to be much strengthened when we see what the pre-existing state of EU law was about rights being treated as being under EU law, even though they go beyond what the directive provides for. Is that right?
Yes.
Okay, we're going to see some cases about that in due course. Okay, well let's
We're about to.
okay.
So I wanted to just pause there and on this issue of Article 13.4, first of all take you to what the judge said below about the textual arguments about Article 13.4.
Okay.
And so that is at in the core bundle at page 47.
So sorry, core. Which page did you say?
Page 47.
47. Sorry.
Paragraph 80, which is the last, and just in the middle of a rather, well, perhaps if we start at 78. Article 13.4 is an entirely new provision. Sphere of application has been hotly contested. Although it is agreed that the appellant does not require Article 13.4 and have particular facts in connection with the fulfilment of the conditions for the grant of PSS. That's because the grant of PSS doesn't require satisfaction of the conditions in Article 13.1. Mr. Cornwall and Mr. Hall submitted that it could not have applied to the appellant's case even had she needed it. Mr. Cornwall endeavoured to persuade me that Article 34 could not apply as a matter of principle to the Act granting me new status and that the relevant provision is Article 38. In other words, if and to the extent that PSS goes further than the CRD, relevant rights being conferred solely under domestic law. His submissions were buttressed by Mr. Hall, who recognised that the ambit of Article 13.4 raised a difficult question. Given the appellant's PSS was granted in November 2020, Mr. Hall correctly, in my view, focused on Article 37 of the CRD and not Article 38 of the Withdrawal Agreement, though nothing really turns on that. Well, we come back to that, but for the purposes of the textual point about 13.4, the endeavour of Mr. Cornwall and Mr. Hall was to demonstrate not that they put the matter quite in these terms, that if Article 13.4 could not apply as a matter of principle at stage 1.
So what is stage 1?
His stage 1 is the initial assessment of whether or not to grant the residence document. His stage 2 is what the residence document grants.
And this is paragraph 70 of the judgment.
It is, thank you, my lord. Yes.
Yep.
He says, I agree with this logic, but I cannot agree with the premise. In my judgment, Article 13.4 could, as a matter of principle, apply at stage 1. My reasons are as follows. In my view,
So just pausing here, am I right in thinking this is the only part of the judge's reasoning which the Secretary of State doesn't adopt?
yes.
That's right.
Yeah.
And in my view, the Secretary of State, in adopting a policy and practice which did not require strict adherence to the conditions in Article 13.1, has removed or disapplied them. As a matter of language, there is a clear and direct pathway from Article 13.4 through to Article 13.1 and then to Article 18.1, each provision referring to conditions. Mr. Cornwall's further submission to the effect that Article 13.4 is only concerned with the exercise of discretions located within a relevant limitation or condition has no appeal. Article 13.4 is not concerned with how a discretion conferred in or by a particular provision in the TFEU or the CRD should be exercised. What Article 13.4 is saying is that the parties to the withdrawal agreement have no power to apply more stringent limitations and conditions than those found in the TFEU and the CRD, but they do have power to apply less onerous conditions. That power will include the disapplication of a limitation or condition located, for example, within a relevant provision of the CRD. Mr. Hall submitted that it seems odd that a provision tucked away at the end of an article in a treaty should have such wide-ranging consequences. That submission has slightly greater appeal, but ultimately was no more than an impressionistic point. I'm guided by what the withdrawal agreement actually says. Nor can I begin to accept the contention that by disapplying the requirements of Article 7 of the CRD, the Secretary of State must be seen as acting under Article 38 of the Withdrawal Agreement, or Article 37 of the CRD, and has therefore conferred rights solely under domestic law. Mr. Cornwall modified that submission under the pressure of oral argument to suggest that the exercise of the power was hybrid, that is to say, both under Article 18.1 and under Article 38. In my judgment, if Article 13.4 is deployed to disapply a relevant limitation or condition, the applicant must, at that point in time, be residing in the UK in accordance with the conditions set out in Title 2, because Article 13 of the Withdrawal Agreement incorporates Article 7 by reference. and his new resident status was issued on that basis. And I'll come on to Article 18 later, but I respectfully submit the judge was right there. That Article 13.4, and we shall see this, the argument I've been making to your lordships is bolstered by Article 18. But what I want to do is firstly to take, before we turn to Article 18, is to take two cases that didn't look at Article 18, but are relevant to Article 13.
And just to be clear, on this logic, as I understand it, well, assuming that 13.4 does what you say it does, in any particular case, the Secretary of State could choose whether to achieve a result by waiving a condition under 13.4 or by achieving the result as a matter of domestic law pursuant to Article 38.
So I accept the Secretary of State can choose to not grant a right of residence under the Withdrawal Agreement. Yes.
I mean, the Secretary of State could achieve exactly the same result as on this thesis, either by waiving a condition or by providing for that as a matter of domestic law.
But it's not the same result, because in one case the person has the protections of the Withdrawal Agreement, and in the other one they don't.
I follow the result is different, but that in that case I expressed my question badly. But they could provide for the same thing one way or the other.
Well, I say they're very different things.
Right.
The Secretary of State could produce an outcome which had similar further outcomes. Yes. So the Secretary of State could say, I'm going to let you stay for 5 years, not under the Withdrawal Agreement, but with no conditions.
So just to be clear, where you find something has in fact been done, is it deemed to have been done under 13.4 because it could have been done under 13.4? Or if not, how do you decide whether it's done under 13.4 or done under 38?
You look at the scheme and the documents.
And is there anything in the scheme or the documents here showing it was done under 13.4, not 38?
Yes, it says it's leave under the Withdrawal Agreement.
What says leave under the Withdrawal Agreement?
The document issued to the appellant that I showed you at the outset, page 3 of the core one.
I can't remember what the exact wording was.
I'll take your lordships back to it. It's in the supplementary bundle.
Page 3, as you say.
It's page 3 of volume 1 of the supplementary bundle. Sorry, I should say issued in accordance with, not under.
Yeah, well, that is quite a difference. Could,
Well, I
mean this
say
is, could simply mean this is something we're entitled to do under the Withdrawal Agreement.
Well, in my submission, that would be stretching the language of it.
Yeah, but the truth is that in one sense this is a formal document because it's evidence of status, but in another sense it's clearly, I can't find it.
In volume 1.
Yeah, I've got it now.
It's page 3.
It's a it's not really a very legally drafted document. It just talks, it doesn't give any references or anything. It just says, in accordance with the EU exit separation agreements.
And then for EU
It does say this is the Withdrawal Agreement.
This is the Withdrawal Agreement.
Yes, okay. But
In
in accordance with.
Certainly my submission, my lord, is that nobody reading this document could think that the holder was not residing under the Withdrawal Agreement.
So if the Secretary of State were now to change the wording of the document that is issued, in the future this argument would fall away.
If the Secretary of State were now to say, I no longer wish to exercise my discretion under Article 13.4, you do not meet the conditions of Article 13.1, you are not residing under the Withdrawal Agreement, then on my argument at this point, subject to arguments about accrued rights and legitimate expectations and so on, yes, the Withdrawal Agreement does not preclude that.
And just to be clear, that could be done just by changing the wording of what's on the internet.
Well, subject to the accrued rights arguments, yes. If you take this document and you say this leave is not issued in accordance with you, if you contradict it, if you reverse it, then it's a different thing, yes.
If it, well, yes, in fact, the way it would probably be done, it wouldn't be said, this document is not issued in accordance, is issued partly in accordance with the I suppose, let me start again. in the case of someone who it is clear isn't entitled under the withdrawal agreement, you could say this is not issued under the withdrawal agreement, but is issued under the EUSS. But the whole policy background of this is you just don't want to have to do these checks. You want to do it in a much more blanket way. So the way it would probably be done, but you say it's significant it wasn't done this way, is you say this leave is issued in accordance with the EUSS, i.e. the domestic legislation, which is actually what most punters know about.
Well, I think what punters
If you are a speaking anecdotally, things I've had to have come across, but people talk about the EUSS because that's what is trumpeted everywhere to people who wanted to apply.
Well, what punters know, my lord, is that this is the document they show to their employers.
Well, that's exactly. But all right. But the point is, what I'm trying to get at, and it's not a point necessarily against you, but I just want to understand it. I'm really following up my lord's point about how this would have to be changed to fit, as you say, the Secretary of State's argument. You say if the case was, if the Secretary of State's analysis was right, this ought to be saying this leave is issued in accordance with the EUSS. The punter would be perfectly happy with that, and the employer would be perfectly happy with that, because that's
Well, no,
what they know about. That's the domestic law.
But the difficulty
they
is,
are in England.
yes, but the difficulty with that, my lord, is the Secretary of State, as we'll see when we get to Article 18, is that where the Secretary of State is issuing a document under the withdrawal agreement, it has to say so. And the Secretary of State can't tell when she issues this document because she's decided not to look whether the person concerned is currently exercising Article 13(1) rights or not.
So you say under the terms of the withdrawal agreement, it is not open to the Secretary of State to say to issue a document confirming status which refers to the EUSS rather than to the withdrawal agreement. Is that what you're saying?
Yes.
Okay, we'll have to look at that in a minute.
But what
just so I make for my note without going to it, what's the provision that has that effect?
It's in Article 18(1)(q).
Okay, that's fine.
Just talking around this a moment longer, I mean, in one sense, plainly, the document you've shown us is issued in accordance with the withdrawal agreement because it is issued pursuant to Article 18(1).
Yes.
On your case, that necessarily implies an exercise of 13(4) power, does it?
It does, but it didn't require the Secretary of State to issue an unconditional leave under the withdrawal agreement. Secretary of State could have adopted a different scheme. The Secretary of State could have said, in my submission, maybe my own friends will disagree, but in my submission, our submission, the Secretary of State could have adopted a scheme which said, this is a document issued under Article 18, in accordance with Article 18(1). It recognises that while you are residing in accordance with the conditions set out in Article 13(1), you are residing under the withdrawal agreement, but not otherwise. And then, and this is important, then this appellant would have known that she wouldn't be entitled to claim the rights under the withdrawal agreement unless she was residing in accordance with Article 13(1).
I see the argument, but that does mean, does it, that there is scope to issue an Article 18(1) document in accordance with the withdrawal agreement without necessarily using your 13(4) power?
Absolutely. Yes, no, certainly that is a key part of my submission.
So why should we take the fact that it says it's issued in accordance with the withdrawal agreement as meaning that there's been an exercise of 13(4) power?
Because that's what it says. Because if
Doesn't
it wasn't,
say that.
because if it wasn't an exercise of the Article 13(4) power, then it isn't a document. Then one can't have been given leave under the withdrawal agreement on the Secretary of State's case. The Secretary of State wouldn't be able to operate the scheme that she has without 13(4). What she chose to do was to say to this class of people, you have leave in accordance with the withdrawal agreement. Now, in order to do that, she needs to have a power to not look at the conditions in Article 13.1. And it has to be a power under the withdrawal agreement because she's acting under the withdrawal.
Just tell me again why she's acting under the withdrawal agreement.
Because that's what the document says, and because she
Oh,
had,
all right, but then
and because she had to, because the applicant made an application under the withdrawal agreement.
I just thought she made an application under the EUSS.
Yes, but it's an application under the withdrawal agreement.
Why do you say that?
Well, because it's an application under Article 18, under Article 18.1.
No, it's an application permitted by Article 18.
And therefore under Article 18.1.
Well, I'm not sure about that.
Well, it's always been common ground that this was an application.
Well, it depends
under
what you mean
Article
by under. I mean,
18. I mean, in full compliance with.
yes, well, exactly. But it may sound like playing with words, but it's actually quite important. The substantive rights we can see are granted by 13.1. There's rights to reside. Article 18 isn't conferring rights at all. There are no rights under Article, no rights to reside under Article 18.
So Article 13 is an international agreement requiring the UK to recognise these that particular people who meet those strict conditions as having those rights, and that is indefeasible.
Or to confer rights might be better than say to recognise, but it doesn't matter.
Okay. An Article 18.1 is the process by which those rights are to be evidenced. The ownership, the possession of those rights are to be evidenced.
Though it's not mandatory.
It's not, it's one of the two routes. But when you take it, when you set up a scheme under Article 18.1, which applies to a class of people, and in the United Kingdom it was chosen to apply to all the people, didn't have to apply to everybody, but you do, apply to the whole cohort under Article 10. And an application is made in accordance with Article 18.1, you must get a document under Article 18.1 or a refusal under Article 18.1. This is the document under Article 18.1.
We haven't yet been through Article 18. Okay, well, I think, subject to my lord and my lady wanting to explore this further, there's been a helpful exploration of your case on 13.4, but there are other bits of the argument which we haven't got to yet.
There are, and I do need to. Thank you. So if I could ask your lordships to turn up the case of CG, which is in Volume 1, Divider 11, at page 363.
Sorry, I missed that. I was just finishing off
My lady, 363 of the authorities bundle. This is the first two cases that I'm going to take you to, and this is the transition period case. So this is when EU rights of free movement still applied, and before the withdrawal agreement, or before part 2 of the withdrawal agreement, came into force.
So just to be clear about that, is there any significance it being transition period? I mean, factually, it might have arisen because the Brexit process has already started, but the law as analysed is exactly the same law as applied pre-transition.
There is a significance because certainly in terms of the fallback argument that is put against me, or at least in terms of the IMA's position, but it's something that I'll need to explore.
Okay, fair enough, yep.
So, Ms. CG, Croatian and Dutch nationality in Northern Ireland, if we see from the head note, after residing there for some 18 months, she was granted pre-settled status pursuant to Appendix EU to the Immigration Bill. So that was at that time a purely domestic grant, because Article 18 wasn't in force yet. And then she applied for the benefit universal credit.
Hang on 1 second.
I'm so sorry.
Yep.
And that was refused, and she appealed on the grounds that this was discrimination. And the tribunal sent the case off to the Court of Justice just before just before Brexit. The judgment begins at page 391. And if I could take your lordships and my lady to page 398, paragraph 31. Which gives us the date for the grant of PSS, which is during the transitional period. And we see the court noting at the end of 31, the grant of that status is not subject to any condition as to resources. Turning then on to page 402, the court decided as a preliminary issue to deal with a point taken by the United Kingdom, paragraph 53. The United Kingdom states that the situation issue in the main proceedings is governed by national law alone and therefore does not fall within the scope of EU law. The temporary right of residence at issue was granted to CG on the sole basis of national law. And the fact that that person was entitled to access the territory of the United Kingdom under EU law for an initial period of 3 months is irrelevant. Court rejects that case at 56 onwards. They note, first of all, at 56, she resided on the territory on the basis of national law from the 4th of June 2020. They then recall in 57 that a union citizen who has moved to another member state.
Sorry, I'm being slow. Resided on that territory on the basis of national law.
Yes. That's PSS.
Right.
So at 57, they then say, must be recalled that a union citizen, a national of a member state who's moved to another member state, has made use of his or her right to move freely, meaning that his or her situation falls within the scope of...
Sorry to be slow. Surely, since this was pre-IP completion date,
yes,
it was not just on the basis of national law, because EU law continued to, under the transition arrangements, continued to apply.
Well, what the court is doing here, and we will get to that. What the court is saying is, we hear you, United Kingdom. The right of residence was granted under national law.
Okay.
And they're now going to say, well, what does that mean for EU law?
Sorry, I jumped in too quickly. Keep going.
So we see under 57 that G must be recalled that a union citizen who has moved to another member state has made use of his or her right to move freely, meaning that his or her situation falls within the scope of EU law. That's the first step of the court's argument. It's within the broad ambit of EU law. And then they deal with what that provision, that interim finding means for the rights to be protected from discrimination. And we see in Article 58 that they say, having observed about the scope of EU law, that H, accordingly, by virtue of having union citizenship, a national of a member state residing in another member state is entitled to rely on Article 21(1). Within the scope of the treaty. So that's the next step of the court's reasoning. And the court then recognises that she is in principle protected from discrimination, and we see that at 64. And I'm going to deal with the whole case in these submissions, so there are some points that are aren't only relevant to 13, obviously. But they say, the court at 66, they say, but actually Article 18, the treaty, isn't the right provision. The right provision, someone like you, is Article 24 of the CRD. That's the governing rule, they say at the end of 67 at D. The person in CG situation falls within the scope of that directive, with the result that it is in light of Article 24 it's necessary to assess whether that person faces discrimination on the grounds of nationality. And they then reframe the National Court's question at 72 to ask whether Article 24 precludes the legislation in question. And they say no, it doesn't. We see that, I won't take your lordship to the detail, 74 to 79, it's common ground that under Article 24, a person who's not economically active was not protected from discrimination in respect of social assistance. That wasn't something that someone with that kind of personal quality could complain about. It didn't need to be justified. They weren't protected from discrimination. We see that conclusion, or we see the explanation for it at 80, over the page.
Sorry, 80.
Paragraph 80, at page 406. They apply that reasoning to CG because they say they've asked national courts.
It's basically applying Darno.
Yes, exactly. But applying Darno to somebody who has a right to reside under national law. They then look at what that right to reside for national law means in a different respect, and we see crucially at 82, they note that this is 3 lines down, even where all the requirements laid down by Directive 2004/38 have not been met. Sorry, I'm so sorry, I've skipped out important words. Starting from the top of 82, it must be noted that national provisions which, like the provisions at issue in the dispute in the main proceedings, noting here that's PSS, grant a right of residence to a union citizen, even where all the requirements laid down by 2004/38 have not been met. That falls within the scenario referred to in Article 37 of the directive. So it is a right that is more generous than those required to be granted by the directive. But what's crucial is the court then holds that Miss CG fell under Article 21 by virtue of that grant. And we see them that at 83 and 84, they first of all dismiss the argument that it was granted on the basis of the directive. It's the first sentence of 83. And they explain their case law, they reiterate their case law that member states can't be flexible in that way under the directive.
Hang on 1 second. I'm just reading it, but I can see what they say, yeah.
F does not in any way mean that such provisions must be incorporated into the system introduced by that directive.
Yeah, well, it's saying if you do something for which the directive doesn't provide,
You're outside
something
the
more
directive.
generous, that can't be treated as being done on the basis of the directive.
Exactly.
Pretty straightforward.
Exactly. The directive.
And so far as it goes, that you will say not in any way that matters, contrary to your case.
No, not at all, as we shall see. Because what it is that the core provisions in the directive can't be messed around with by the states. They can't be more generous under the directive. The union wants to know who's residing under the directive and who's not. But what we see at 84, that said, as pointed out in paragraph 57 above, a union citizen who, like CG, has moved to another member state, has made use of his or her fundamental freedom to move and to reside within the territory of the member states, conferred by Article 21(1), with the result that his or her situation falls within the scope of EU law, including where his or her right of residence derives from national law.
Yes, all that mean, but that doesn't mean that you have the protection of Article 18 of the TFEU.
True.
It's simply, which they've already excluded in their argument, it just means you come within the scope of the Charter. And nobody's running a Charter case here.
It means you come within the scope of the EU law system, the international system. In other words,
Well, what bits of it?
Article 21.
But not Article,
But not Article...
but not Article 18.
because there was a more specific.
Well, quite.
provision.
So
And
where
we
does
don't
this
rely-
get? This doesn't really help you, does it?
Well, I do. I say no. I say it helps me a lot because what I say it shows is that the position down to the end of the transition period is that the court had recognised that member states could, by their own actions, bring people under Article 21 of the treaty.
So again, it's important because it shows that
The court recognised that down to the end of the transition period, member states could, by their own actions, by their own purely domestic law provisions, such as PSS, bring a person or lead a person to be residing under Article 21. And we get that from 87
I see that, but why does that help you if you have not bringing a case under Article 21?
because the analogue to Article 21 is 13.1. And so it's seeking to address the point that's been put to me by the bench. Well, why would EU states want to be able to bring people within the international law system when they can just do it under their own purely national law system? And the answer is because that's the status quo ante. That's the CG position. And if I could just finish.
When you say it's the analogue of Article
I just-
13,
My lord, can I just, before I say that, because I hadn't taken you to the crucial last wording, 87.
yes, of course.
At 87, at 407, in the present case, it's apparent from the order for reference that the UK authorities granted CG a right of residence even though she did not have sufficient resources. As noted in paragraph 82 above, those authorities applied more favourable rules in terms of the right of residence than those established by the provisions of Directive 2004/38, with the result that the action cannot be regarded as an implementation of that directive. In so doing, those authorities, by contrast, recognise the right of a national of a member state to reside freely on its territory conferred on EU citizens by Article 21(1), without relying on the conditions and limitations in respect of that right laid down by Directive 2004/38. In other words,
It's opaque. Why isn't that contrary to the whole thrust of the argument up to that point?
why isn't it contrary to the thrust of the argument? You mean
Well, the whole argument up to that point is Article 21, and we saw this earlier, doesn't confer rights, or at any rate doesn't confer unconditional rights, where there has been more specific EU legislation,
yes,
here the directive, which does confer conditional rights,
yes.
or it does impose conditions on the rights. So where does the second half of 87 get you? The 87 is saying, okay, you haven't got rights under the directive, but Article 21 still applies. But so what?
Well, what it's in.
The only so what, surely, is the Charter applies.
So what then? But so what now is that it shows that the continuation of the scheme that was in existence then means that Article 13(4) should be interpreted as providing the same outcomes as applied under Article 21, where you choose to grant under national law a right, or that you can choose to grant under national law the right under the Withdrawal Agreement.
This doesn't depend on any equivalent to Article 13(4).
It doesn't. No. No. It is a holding by the court.
It says you're outside the directive, but you're still within Article 21.
The inner ring, the directive, is fixed. Member states cannot fiddle with it and be more generous or less generous. The outer ring, Article 21, whether or not one falls within that donut, can be granted by the state concerned. And I say that's the same under the new scheme. The inner ring, 13(1), can't be shrunk. But the outer ring of 13(4) is a matter of national discretion, just as it was under the EU law scheme. So I say that it's the Secretary of State who changes the operation of the residence scheme with her arguments, or rather she changes the rights of states under the residence scheme. She says to Greece, at the moment, you've granted residence permits to UK citizens who have these particular circumstances. It doesn't fall under the directive, but by granting that permit, they fall under Article 21. What happens to those UK citizens at the end of the transition period? Well, on the Secretary of State's logic, Greece no longer has a power to bring them under the withdrawal agreement. It can no longer exercise the system that it was exercising before. It now can't do that. It has to say, oh, terribly sorry, you're national law now. Okay, we're trying to give you the same rights as the withdrawal agreement, but we can't bring you under the withdrawal agreement.
Why is that a bad thing?
It's because it would be a strange thing to states to take away their powers and discretions.
It hasn't taken away their powers and discretions.
But it has, because they've got a power and discretion to keep people under the international scheme, as long as they...
But what's the advantage of being under the international scheme? All that matters is that nobody doesn't say you must leave Athens, in your example.
Well, you say for the individual, but what it matters for the state is that the state knows who it's dealing with and how it's dealing with them, and it has different systems for dealing with EU cases from its own domestic immigration law. It doesn't want to have these consequences, and we'll see that when we get to what the Secretary of State said about how they wanted the system to operate. But can I just take your lordships first to AT, which follows from CG. And that's a divider 43, which is in volume 2 of the authorities. And CG is the, sorry, AT is the case after the transition period. It's another case of someone granted PSS who couldn't meet the conditions of the directive. She was in fact granted it shortly before the end of the transition period, but the benefits claim that she made was made after the transition period, and therefore when EU law had ceased to apply, and the court was therefore forced to look at the withdrawal agreement. And we see at page 1354 the context for it, or the way the case came before this court. The appellant had won before the first tier tribunal, and we see that it's between E and F. First tier tribunal allowed the claimant's appeal finding.
So sorry, did you say page 1394?
So sorry, 1354.
1354. Thank you. Yep. Yep.
Between E and F. The first tier tribunal allowed the claimant's appeal, finding that without universal credit, the claimant and her daughter would not be able to live in dignified conditions, which is a reference to Article 1 of the Charter. Secretary of State appealed that to the upper tribunal, and then lost there and appealed it to the Court of Appeal and lost again. The Court of Appeal was not asked to consider any discrimination arguments. And I understand from the IMA skeleton that discrimination had been raised before the UT, but it appears to have been one of those issues that the UT did not reach. And for the notes of the court, that is at paragraph 8 of the UT judgment, which is at page 1, it's at 1486 of the bundle. I don't need to go there. So the fact that this court did not consider discrimination doesn't weigh against the appellant's case, contrary to the suggestion in the skeletons. And I say, in fact, it strongly supports the appellant's case. Firstly, I'd like to just take your lordships to paragraph 47 of the judgment. There were many different arguments raised, but I'm going to try to deal with the ones that are relevant here. Simply to note at E, it's common ground that until the expiry of the transition period, the entirety of the EU law applied, but thereafter only those provisions given effect to in the withdrawal agreement are applicable. And then turning over to 49, we see the reasoning of Lord Justice Green, with whom both Lord Justice Tingermans and Lord Justice King agreed.
Lady Justice King.
Yes. And we see at 49, him saying, it is perhaps a statement of the obvious, but the agreement reflected the end result of difficult and complex negotiations, and its final terms embody compromise or overall balance, as is diplomatically expressed in the recitals. Now at 55, the judge says, I now turn to the substantive right to reside. And he refers to the recital, sixth recital, which I've already taken you to, and then he refers to Article 13 and says, I address below the dispute between the parties as to whether this cross-referencing to Article 21 imports the full right in Article 21 or only its limitations. Provision addresses the rights of citizens of the Union or the United Kingdom who reside in a host state, and also covers the derivative rights of family members. Subparagraph 4 lays down a principle of the asymmetrical exercise of discretion when considering limitations and conditions attaching to rights of residence, which is what I say is correct. It should be noted at 57 he refers to Article 23, but then doesn't deal with it thereafter. Turning to paragraph 70, we see the court's analysis of CG, Mr. Lord Justice Green's analysis of CG. The court, that's the Court of Justice, reiterated that CG was via the withdrawal agreement. I think that's shorthand for via the grant of pre-settled status, exercising a right founded in EU law.
Hang on 1 second.
So where it says the withdrawal agreement, you say it should be PSS.
I do, yes, because the withdrawal agreement wasn't in force, and the court, I think, that isn't the way that the court had expressed it.
Thank you. Yeah. Sorry, yes, I slowed you up there. Paragraph 70, just referring to the first sentence.
Yes, the
Yeah,
court
okay.
reiterated that CG was via the withdrawal agreement, and I think that should be taken as shorthand.
Yeah,
from
we got that.
Thank you. Turning then to 89. The judge quotes from the upper tribunal's decision at paragraph 106. CG establishes that the UK was implementing or acting in the scope of Article 21 TFEU when granting CG the domestic law right of residence on terms more favourable than required by the CRD. The same is true in relation to AT. And remember that the upper tribunal was dealing with the period after the end of the transition period. CG also established that SSWP was acting in the scope of CG's Article 21 TFEU right to reside when deciding her application for the social assistance necessary to make that right effective. SSWP was applying AT's modified Article 21 right to reside, the right conferred by Articles 10 and 13 of the WA, when determining AT's application for UC. Now, we see that the Secretary of State disputed that analysis in the next paragraph, quoting from paragraph 47 of her written submissions. Crucially, this is an argument that the decision under appeal, the Social Security decision, wasn't interpreting or applying Article 13 of the WA. Interestingly, we see below F, if the Secretary of State could be said to have been applying any provision of the WA when deciding her claim, it was Article 23. What's significant perhaps there is that there's no argument there that AT didn't have any right to reside under Article 13.1 on the basis that she couldn't have it because there wasn't a power under Article 13.4 to grant it.
Was any point being taken on 13.4?
My point is the Secretary of State didn't take the point.
Why would the Secretary of State need to take the point?
Because it would have defeated the case.
My lord, it really wasn't the issue in the case. I hesitate to stand. I was in that case, and it simply wasn't in anybody's contemplation because it wasn't one of the issues in the documents in the case.
And what's so significant, my lord, is that
But these are the points not taken points. I never.
it's not a point. The significance of it, my lord, is that if it had been the Secretary of State's understanding that Article 13.4 couldn't be used, that a person could only be residing under the withdrawal agreement at all, if they met the conditions of Article 13.1, then 80 is wrongly decided. If that's right, then 80 is
Well,
wrongly
that's a
decided.
point you can make, but
Sorry,
at the it's never helpful, particularly in a developing area of law where different people take different points
No, I entirely accept that.
to argue about what this shows us about 13.4.
But
Your more general point is broadly, if the Secretary of State's analysis in this case is right, 80 was wrongly decided.
Yes.
Is that right?
Yes.
Okay, well, let me just write that down.
Because...
Hang on one
Of
second.
course. Because the anchoring right of residence referred to in 18 is a right of residence under Article 13. That it was common ground that AT didn't meet the conditions in Article 13.1. In the sense of having a right under Article 21, notwithstanding PSS, to reside. Only way that we could reconcile the AT with Secretary of State submissions is that PSS brings you within Article 13.1. Now, just pausing there to explain the two ways in the different parties say that that can happen, I say that's 13.4. The IMA say that if you were granted PSS before the 31st of December 2020, then you fell under Article 21, CCG. And therefore you must continue to fall under Article 21, under the new Article 13. The problem with that argument is, in my submission, what happens if the PSS is granted after the 31st of December, after EU law, and there was never any Article 21 in play?
So how long was so there was a 6-month period after IP completion day when the scheme was still granting fresh PSS?
6-month period to make the application, my lord.
Yes, right,
Millions of people were given PSS after the 31st.
No, to make the application, yeah. And the point is it's a limited period, though subject to some exceptions, I think.
It's limited for people who are already residing here, but
No, it's limited to people making an application before a certain date.
But for new arriving family members, they can make the application when they choose to arrive.
Well, all right, but let's leave family members out of this. I'm just...
I mean EU citizens who are family members. So I mean, PSS will go on being granted for decades from now. Unless the scheme changes. And hopefully not on applications already made, but on applications to be made. So it's not, the important point here isn't the Secretary of State missed a point she could have taken. The important point is that the rights under the Charter rest upon a finding that the person is residing under Article 13. And if the Secretary of State is right, she pulls the Article 13.1 rug out, or the Article 13 rather, rug, out from under the Charter. And we see this in Lord Justice Green's reasoning at paragraph 91 at the top of 1386.
Yes. Yep.
Just that the relevance of the judgment in CG is that it concerns the application of the Charter to persons who have rights under Article 13 of the agreement, which is a category that AT falls into. My Lord, a quick point at 94 to simply bolster my case that one would expect Article 13 to provide the same discretionary powers that Article 21 provided, because 13 is a continuation of 21 in that sense. And this is the judge's rejection of the arguments that at 93, that Article 13 creates a standalone right but didn't bring Article 21 rights across. And he says that's wrong. 94, by its language, it brings Article 21 TFEU into effect through cross-reference. And to emphasise the point that AT had a right to reside under the Withdrawal Agreement, 99 at the top of 1388. AT has a basic or anchoring right of residence which predated but also subsists beyond the transition period. That EU law based right became an international law right under the Withdrawal Agreement and is now encapsulated into PSS, the domestic right protecting prior withdrawal agreement and union law rights. I say that's right. I say that's what PSS does. And then at 101, the judge deals with an argument that, yes, so I should say that the judge then reaches the answer to the point raised at 96, I'm sorry to go back, which is the Secretary of State's case under this section of the judgment is the judgment in CG applies only to cases arising during the transition period. It does not apply to a person applying for support thereafter. That's the point he's answering. And so at 102, he then deals with the Secretary of State's argument that CG was a radical departure from settled case law, baffling and perplexing. He disagrees with that. At first, the judgment does not represent an evolution in the case law. It does represent an evolution in the case law, but it's far from baffling or perplexing. Secondly, even if it is an extension of the law, then so be it. Under the Withdrawal Agreement, this judgment binds the UK under provisions agreed to by the UK. Thirdly, no one has put any evidence before the court indicating that the burden on the state brought about the application of the Charter is at all significant. A point perhaps of relevance to issue 3 here, not directly relevant to this. And then we see, finally, as to the implication underpinning much of the argument that the judgment is somehow unfair to the UK, the residence provisions, which in my submission here refers to the Withdrawal Agreement, are designed to protect UK citizens living in the EU to the same degree as they protect EU citizens living in the UK. I'm reading at the bottom of 1388. The agreement imposes obligations on the UK and the EU and the member states in equal measure. There can be no sense in which the judgment imposes unfair burdens only on the UK. And I rely on that, and I say that if there are burdens that flow from the Secretary of State's scheme, having chosen to adopt a easy to operate in an administrative sense scheme, then they are burdens that the UK has chosen to take on. If they're burdens that arise from the UK's choices by operation of the Withdrawal Agreement, in other words, having made the choice, the Withdrawal Agreement then requires that certain consequences follow, like a right of equal treatment, they are burdens the UK has chosen to take on. Turning then to the points made in my skeleton arguments, paragraph 30. So I say, first of all, that Article 13 should be interpreted in the same way as Article 21, with Article 13.4 recognising the same power to grant a right of residence under the WA, under the Withdrawal Agreement, as the power which Article 21 gave to grant a right of residence under EU law, regardless of the satisfaction of the conditions and limitations down in the CRD. That would provide precise continuity of the discretionary powers of the UK and of the EU member states as regards rights of residence from EU law to Withdrawal Agreement law. And it is the government's position which would be the radical break, taking away the discretionary power to grant a right of residence that brings into operation the international law scheme.
Sorry, I'm being slow. Surely there's a discontinuity on your analysis as a result of what the Secretary of State has chosen to do, because prior to Brexit, prior to the Withdrawal Agreement, people residing with for more than 3 months without complying with the conditions had no rights under EU law and therefore no anti-discrimination rights. If you're right, that has ceased to be the position. So that's a discontinuity. Now, I quite understand your argument. It's a discontinuity which is a consequence of the choice which the Secretary of State has made under 13.4. That may be right, it may be wrong. But I can't understand on what basis there's continuity.
So the distinction is, in my submission, between Article 13 and Article 23. So I'm jumping ahead of myself a little, but there's continuity under Article 13. If we look at it from an immigration point of view, under the EU scheme, if the state gave somebody PSS, they were thereafter residing in accordance with the international scheme.
But nobody did give people PSS before Brexit. They didn't exist. It was a non-existent status.
No, but PSS was given to CG before.
Oh, I see. So, right. So the continuity is not from the pre-Brexit position. You accept the discontinuity from the pre-Brexit position.
Well,
you are saying that there is, as soon as the EUSS was introduced, which was in the interim period.
Before, actually.
That's when the sorry?
It was before, introduced before the transition period.
Exactly, that's why I said the interim period. No, it wasn't. No, sure, it was introduced during the transition period.
No, the grants began in 2019.
When did the transition period start?
31st of December 2020.
Began in January.
Sorry,
Began in January.
I'm so sorry, I meant 30th of January 2020. Sorry.
Yes, I see. That's the formal transition period, because that until that point the withdrawal agreement hadn't come into force.
Hadn't been agreed.
Well, right. Okay. But that was I didn't actually use the phrase transition period. I used the word interim period. We had given notice under Article 50, had we not?
Yes. Oh, yes. I agree with your lordship that.
And indeed, the EUSS was introduced in advance of the withdrawal agreement, but knowing roughly what the withdrawal agreement was going to say about residence rights.
Yes. Yeah. But the point that CG illuminates is not just PSS. It's any domestic grant. So that was a power that member states had.
I don't want to get too far from the point I was just trying to clarify. The point I was trying to clarify was that you accept there is a discontinuity with the pre-Brexit position, but you say there is a continuity with the position once the EUSS had been introduced.
I say there's a residence rights continuity on my arguments. If I'm right, there's a residence rights continuity, and there's a consequential welfare benefits rights discontinuity. If the Secretary of State's right, there's a residence rights discontinuity. There are a lot of people who don't have rights under the international agreement anymore, but you've got a benefits rights continuity. So Article 13.1, which is much more than benefits, of course, applies in my argument in the same way as Article 21 would have applied, because 13.4 clarifies, confirms, grants the discretion. On the Secretary of State's argument, the states chose to radically shrink their powers and that the withdrawal agreement wouldn't operate like Article 21, it would operate like the CRD.
Is this really like CG and Article 21? I mean, in CG, the Court of Justice wasn't saying, was it, Article 21 applies because the state has a discretion under some instrument which it has exercised. It's simply saying, if the state lets somebody in the context where there is a general right to exercise rights of free movement, well, you're within Article 21. It's different.
But I say that AT is built on CG, and CG says that where you grant a domestic law right, you are residing, the state has waived the limitations and conditions of Article 21, and the person is residing under it. That's the foundation of AT.
Quite say that.
I say that's how it was interpreted by this court when it approved the upper tribunal's reasoning in AT. And in my submission, that is the correct interpretation of the closing paragraphs of CG.
And I suppose you say, whether it's a correct interpretation or not, it's a binding interpretation, because it's
yes.
interpretation by this court.
Oh, yes.
It's part of its ratio.
An essential part of its ratio. Because if, in fact, AT didn't have a right to reside under Article 13, then how could she rely on the provisions of the withdrawal?
Well, you have to be careful about that. Ratio isn't points that are assumed, and that the ratios ought to be points which are actually adopted as part of the reasoning.
That's true.
I can't remember what the case
But in my
says
submission, it's clear that that is part of the reasoning
Yeah.
from the extensive citations that I've taken at court too. So just returning to my skeleton, look at the purpose and why the purpose of the withdrawal agreement supports the points I've been making. First of all, as I say, continuity of practice. Not only the UK, but member states will be able to continue to operate their schemes in exactly the same way as they presently do. That is, granting residence permits under European Union law or under the withdrawal agreement, even though a person does not meet the strict requirements of EU law or the withdrawal agreement. They won't have to distinguish between UK citizens and other people. Secondly, certainty. This allows for states
Sorry,
to
just what was the headline for the first point?
continuity of practice. It's a purpose.
Continuity,
I say that's a purpose of the agreement.
certainty.
Certainty, it means that states don't have to look at Article 13.1. They can simply say, we certainly count you as a person with a right to reside under the withdrawal agreement. Third, flexibility, and here's the last thing I want to take the logic to before the break, which is in the supplementary bundle, in
Core supplementary.
core supplementary bundle in bundle 3, which I hope has now reached your lordship.
Bundle. No, what I didn't have was the authorities bundle.
Oh, my apologies. Sorry. Oh, there we are. Bundle 3 of the.
Sorry, I'm getting confused. I thought it was core supplementary bundle.
Core supplementary bundle.
So it hasn't got a bundle 3. It's a single bundle.
Okay, it's all in one folder then. I'm so sorry, I didn't realise. I have it in 3.
Okay,
Page
sorry.
1408.
Tab 3, is it?
It is tab 8.
Tab 8.
That's the supplementary bundle 148, it must be.
I'm sorry, it's on the internal numbering of the supplementary bundle.
193.
Reference bundles.
Would you want the technical note,
Can we?
Yes.
which is in the supplementary bundle?
Oh, I'm so sorry. My
Can we start again? We have got a core supplementary bundle, and we have also 4 supplemental bundles. And the same things are. The core is simply extra out of the main ones out of the 4. So you're referring us to the.
There is a technical note at tab 13 of the core supplementary bundle. I don't know if that's
Is it page 1408?
no. That's page 284 of the core supplementary.
This can't be right. I mean, it's what bundle. I'll be cross, but
Sorry, but I just might turn my back.
are you not using the same bundles as the rest of us?
I thought I was.
It's confusing because there is a core supplementary bundle and a supplementary bundle.
I know, that's what I've just been
And
explaining.
I think Mr. Potts is referring to the main supplementary
Yes, yes.
bundle.
Works electronically.
That's what I suggested to him, but he,
Yes, well, apparently I am, and apparently it's page 1408 of that bundle.
And that's not the same as tab 13 of the core supplementary bundle.
No.
okay, so 1408 of so the supplementary bundle, which volume of it?
I'm told there's only one.
No, there are 4.
I think it is the same as tab 13 of the core supplementary bundle.
Is it?
Look,
it's
come
a
on, this is
technical
the, I
note-
don't want to be cross, but look, this is extraordinary that we don't know what bundles we've got.
I agree, my lord. I'm sorry. It's I had thought that this bundle.
Okay, I'll stop being cross. Let's find it.
Thank you.
Where are we going? Somebody must know.
Page 284 of the course.
Page 284 of the core supplementary bundle. I'm so sorry. It's
No, don't worry, don't worry. I'm sorry.
I paginated with different numbers, and I'm sorry. I had
284.
yes.
Okay, I brought a technical note. Now, I think we're coming up to 1 o'clock.
We are.
Why don't we make the point after lunch? Would you like us, as an apology for being cross with you, to read?
It's just one. It's just one paragraph.
All right, well, we'll read the paragraph.
Paragraph 2. I should note this is a note from 2017. Paragraph 2, 3 lines down. Obtaining this status will be a condition for lawful residents in the UK and enable these people to easily prove their unique status and rights as guaranteed by the agreement to the UK authorities, employers, public service providers and others in a convenient way in the future.
Yep.
And I use that to illustrate the importance to the parties of flexibility of administration.
Very well. Hang on 1 second. Right. Now, I haven't got in front of me your timetable, which I don't think I managed to leave behind. You were basically to go on till early afternoon and then hand over to one of the interveners. I forget which.
Yes,
Now, are you up to the timetable?
I'm afraid I'm rather behind.
But there are 2 ways of dealing with this. One, and I've got no views about this, but you may. The interveners on your side, who deal with round 1, were given rights to make oral submissions without any time limit. Clearly, sometimes it was implicit, but it wasn't stated. You have given them whatever you've given them. If within your side it is agreed that you can eat into their time, that would be a sensible outcome. If the only thing we don't want to lose is any points that only they make.
Yes.
But I'm not going to offer any analysis about that. But the short point I'm making rather lengthily is you can take more time at the expense of your interveners.
Yes.
If that doesn't work, then we can reconsider the timetable on the basis that we're not going to deal with round 3. Have some thought about that over lunch.
Will do.